Welcome to Lecture 11. In this lecture, we will continue to discuss factors that influence judicial behavior. Specifically, we'll turn our attention to the role attorneys play in the judicial process, especially during oral arguments before the Supreme Court. So it complements nicely the topic that we just talked about. We'll consider whether or not an attorney can actually sway judicial decision-making through his or her arguments, and we'll consider what characteristics of the attorney seem to lead to greater success before the court. In the next lecture, that is Lecture 12, we'll turn our focus to one especially prolific attorney, the United States Solicitor General. Representing the United States government in litigation before the Supreme Court, the Solicitor General prevails more often than any other attorney, so this one sets the stage. So after we discuss the way that general practitioners fare before the court, next week we'll talk about why the Solicitor General is not like all of the attorneys that we're talking about today. So you can think of these two lectures as step 1 and step 2, or part 1 and part 2. Today, though, we're going to focus on the general, run-of-the-mill, normal attorneys, not the Solicitor General, and we want to know how attorneys gain access to the Supreme Court, what role attorneys play in the Supreme Court's decision-making process, and as usual, tie this into our theories of judicial decision-making to see if any of the theories make room for attorney influence, and ultimately we'll evaluate some empirical evidence to see whether one theory is more persuasive than others. Let's begin with a couple basic and background facts about the legal profession in the United States. As of today, there are roughly 1 million lawyers in the United States, or approximately 1 for every 280 citizens. The legal profession has changed across time. In the 1970s, it was a really male-dominated field, with women outnumbered 36-1. Today, on the other hand, women make up more than 30% of the legal profession and account for more than half of the students in law schools. While there's been progress in alleviating gender inequality, disparities on race persist. Both Blacks and Hispanics consist of only about 4% of the entire legal profession. In the United States, a lawyer must be admitted to the bar to practice law in a given system. Thus, each state administers its own bar exam for attorneys to practice law within that state. Bar admissions vary across state and federal systems, and admission to the bar in one state does not automatically transfer across state boundaries or to practice at the federal level in either district courts or the federal courts of appeals. Likewise, if an attorney desires to litigate before the Supreme Court, he or she must be admitted to the Supreme Court's bar. To qualify for admission, the attorney must be a member of the bar of the highest court in his or her state of origin for at least 3 years before asking to be admitted to the Supreme Court's bar. With the application to the Supreme Court's bar, along with other various materials, the lawyer must submit 2 letters of recommendation from current members of the court's bar. If the attorney doesn't meet the experience requirement, he or she can still be admitted on a pro hoc vice basis, which means for this occasion in Latin. While the bar requirements might weed out particularly bad lawyers and tries to establish a minimum level of attorney competence, it tells us absolutely nothing about the impact attorneys have on Supreme Court decision-making. Thus, we can approach the study of attorneys in the court from a social scientific perspective. In particular, we'd like to know, what role do attorneys play in the court's decision-making process? Do they matter in any meaningful sense? As the good social scientists that we are, when we examine the role of attorneys before the court, we ought to consider what the theories of judicial decision-making tells us we might expect to see. Recall again that there are 3 primary theories or models of judicial decision-making that we've been looking at all semester: the legal model, the attitudinal model, and the strategic model. So let's consider each of these 3 in turn. The legal model contends that judicial behavior is driven primarily by what the law says. Thus, the justices are simply trying to discover and apply the law. This doesn't leave much room for attorneys in judicial decision-making. Instead, things like precedent and the language of the law are far more important than the identity of the person arguing the case. In other words, the law matters objectively on its own, and the arguments of the attorneys are irrelevant. Similarly, the attitudinal model would predict that attorneys do not play any substantive role in judicial decision-making. This theory suggests that the justices make decisions based only on their attitudes, their policy preferences, their ideology. Thus, no matter what an attorney says or does, he or she is not going to influence the predetermined preferences of the justices. Only the strategic model of judicial decision-making leaves room for attorneys to influence court outcomes. The strategic perspective argues that justices are driven primarily by their policy preferences, but leaves open the possibility that other factors, like the court's procedures and other legal considerations, could impact a justice's decision in a case. At first glance, it might seem reasonable to expect that attorneys themselves have very little influence over Supreme Court justices' decisions. Indeed, it might seem that oral arguments are a mere formality, especially since attorneys are typically only granted a half an hour before the court to make their case. But on the other hand, there are good reasons to expect that litigants' arguments contained in both their filed merits briefs and presented during oral argument might affect judicial behavior. Why? Well, because the cases that make it to the court are often really hard or complex cases presenting difficult legal questions. The justices often face a lot of uncertainty in a case. The attorneys then provide the justices with critical information. They provide the justices with information about the legal issues before the court, about the relationship between those issues and existing law, and about the implications of the court's decision for public policy at large. A skillful lawyer ought to be able to frame the argument in such a way to advance their client's cause. All right, so now we'd like to be able to say something empirically about the effect that attorneys have. In particular, we want to know if, when, why, and how attorneys influence judicial decision-making. The initial wave of research into this question was conducted primarily by a political scientist named Kevin McGuire. In various published works, Dr. McGuire makes an argument about the role of attorney experience, arguing that there is a link between experience and attorney success before the court. This so-called repeat player argument is one of credibility. In particular, attorneys that have more experience litigating before the Supreme Court establish credibility with the justices, which means that the justices might be more likely to trust the arguments presented by an experienced litigator. Additionally, lawyers with more Supreme Court experience are more likely to know the preferences of the justices and how to frame their legal arguments to reflect those preferences. And the evidence suggests that there is merit to this intuition. When there is a differential in attorney experience, the more experienced the attorney is, all else equal, compared to his competitor, the more likely the experienced attorney is to win. Let's take a look at this graph. If the petitioner's attorney has a lot of experience and is pitted against the respondent's attorney who's participating in the Supreme Court for the very first time, we're looking at the difference in experience on the x-axis. So the petitioner is the most experienced all the way to the left on the x-axis. The respondent is the most experienced on the right. So the difference between the petitioner and the respondent and the probability that the petitioner wins. So if the petitioner is experienced relative to the respondent, so the respondent's attorney is arguing for the first time, the petitioner's attorney has argued many times, we estimate the odds that the petitioner wins is about 70%. This is exactly reversed if the respondent's attorney is more experienced than the petitioner. If that's the case, that the petitioner's attorney is a newbie and the respondent's is the most experienced, the likelihood that the petitioner prevails is only 30%. If the attorneys are of relatively equal experience, the likelihood of winning the case is roughly equivalent with, again, that slight edge for the petitioner, which, again, corresponds to the real-world probability that the petitioner has a slight edge. Again, just to review, because I know maybe we've forgotten, that intuitively it makes sense that petitioners have a slight edge in the court, that petitioners are more likely to appeal a case they've lost in a lower court if they think there's a good chance that the Supreme Court will overturn the lower court's decision. If petitioners thought they'd lose again at the Supreme Court, it wouldn't be very rational to appeal the decision and to incur the time and resource costs. So, but at the baseline expectation is that petitioners prevail at the Supreme Court about 60% of the time. And that's what we see with these expected probabilities as well. The experience argument is really interesting, it's notable, but it's not entirely satisfying, right? Because what we really care about is the quality of argumentation, whether whether making good arguments, whether the quality of your arguments makes a difference in the likelihood that a side will prevail. And this gets right to the heart of refuting the attitudinal model. If the attitudinal model is right, that justices' decisions are all about ideology and nothing else, then no amount of smoke and mirrors in an attorney's arguments will change the justice's perception of the facts. But if the attorney's argument matters, the quality of the argument should hold. But how do we compare the quality of attorney arguments before the Supreme Court? Enter a relatively recent study, now more than a decade old, but something that Tim Johnson, Paul Wolbeck, and Jim Spriggs did in 2006. To capture the effect of oral arguments generally, and attorney quality specifically, those researchers analyzed unique archival data, sorting through the private papers of Justice William Blackmun. It turns out that during oral arguments, Blackmun actively evaluated the attorneys participating in the proceedings. He wrote substantive comments about each attorney's arguments and then assigned an overall grade for the attorney's presentation. What you see before you here is a snapshot of one of Blackmun's notes in a case from 1987. While it's undoubtedly difficult to read his handwriting, hopefully you can see for that each attorney in the case, so I've circled a couple of them here, so 2 different attorneys. Next to their names, he graded their presentation a 5, this little 5 here. So both attorneys, he graded the same, a 5 out of an 8-point scale. So I'll just give you a couple of examples. Don't worry about trying to read everything on the screen here. But in a case from 1982 called Florida Department of State versus Treasurer Salvers, Blackmun wrote 10 different comments about the respondent's attorney, concluding, quote, "He makes the most with a thin, tough case." He graded that attorney a 6. In a 1981 case of First National Maintenance Corporation versus the NLRB, Blackmun wrote that the petitioner's attorney had persuaded him to reverse and scored that attorney a 5 on his 8-point scale. Sometimes his evaluations were tough, like as an example from a 1982 case of Murphy versus Hunt, he wrote that the assistant attorney gave a very confusing talk about Nebraska's bail statutes. He assigned a score of 4 to the assistant attorney general in that case. Throughout his service on the court, Blackmun consistently graded the attorneys during oral argument, though he was a bit inconsistent with his grading scheme, shifting from different point-based systems like we looked at on the previous slide to letter grades. But Johnson, Wolbeck, and Spriggs undertook the task of standardizing the scores across time, so it would be possible to compare his assessments of the different lawyers that participated in oral arguments. Based on Blackmun's substantive comments in his evaluations, it's clear that Blackmun assigned higher grades to attorneys who he believed presented higher quality arguments. This graph shows an almost normal distribution of attorney grades throughout Blackmun's service on the court. So there are many clustered at just above average, some a little bit below average, very few receive high or very low negative marks, and very few receive the highest praise from Blackmun. So we're sort of clustered in the center. But the question becomes, what attorney characteristics influence the quality of arguments presented during oral proceedings? In other words, who scores higher grades? Johnson, Spriggs, and Wolbeck found that there are indeed attorney characteristics that systematically lead to higher scores. The first is attorney experience. Like the earlier waves of research, the ones by Kevin McGuire that we talked about, this analysis confirms that attorney experience matters in oral argument. In short, more experienced attorneys do seem to edge out their competitors, providing higher quality arguments before the court, and Blackmun subsequently rewards them with higher grades. The analysis also reveals that former Supreme Court law clerks receive consistently higher grades from Blackmun. After clerking for a Supreme Court justice, attorneys apparently have a better understanding of how to frame their arguments to garner 5 votes in a case. Similarly, they've had experience with the types of arguments that do not move the justices and are more apt to avoid those kind of arguments in their presentations when they're on the other side of the bench. Attorneys from elite law schools also systematically receive higher grades. Remember that a key role of oral argument is the presentation of information to help the justices make decisions. The justices, or at least Blackmun, seem to think that attorneys that graduated from prestigious law schools are more credible or better sources of information. The grades certainly reflect this belief. It could also be that because all of the justices on the court went to those elite law schools, that the attorneys and the justices just share a common language, and so those attorneys from elite law schools are just better able to harness language in their favor. But we see a few other factors come into play as well. Non-governmental attorneys that practice law in the District of Columbia are also statistically significantly rated more favorably. The intuition here is that given their proximity to the Supreme Court, DC attorneys are seen as, again, more credible sources of information. They've also likely had more exposure to the court and are better adept to frame high-quality arguments in such a way to appeal to the justices. And finally, Justice Blackmun scores attorneys slightly higher if he and the attorney are ideologically compatible. That is, they are of the same political disposition. However, it's very important to note that this effect is really rather small. While Blackmun seems to favor his ideological allies, there isn't a major systematic effect, which suggests that his grades of oral argument of the quality of oral arguments is not unduly affected by his own ideological predisposition. This is a very good thing because it gives us more confidence in the objectivity of his grading system. To this point, we've established that Blackmun's oral argument notes allow us to tap into the quality of the attorney's arguments that are presented in the case before the Supreme Court. We've also seen that certain characteristics of the attorney also systematically lead to higher grades from Blackmun's scorecards. But in the end, we want to know if the attorney quality matters. The evidence suggests that justices do indeed respond to the quality of oral argument. This graph is from Johnson, Spriggs, and Walbeck's research, and it shows that justices across the ideological spectrum are influenced by attorney quality. It's a bit of a technical graph since it digs into concepts like standard deviations, which we haven't talked about, so let's break it down in plain English. Basically, justices that are relatively ideologically more proximate to the attorney exhibit the greatest influence. So we're looking at this ideological compatibility above the mean, which means that the attorney and a justice are closer ideological allies, and we're looking at increasing quality of oral argument on the x-axis, the probability that the justice votes with that attorney on the y-axis. So this means that if a justice is ideologically predisposed to support the position of a particular side, quality arguments by the attorney only serve to strengthen the likelihood that the justice will vote in support of that particular litigant. In this example, the attorney is arguing for the Supreme Court to reverse the lower court's decision, which is what you see on the y-axis. But amazingly, even justices who are ideologically opposed to the attorney are more inclined to side with that lawyer if the lawyer makes quality arguments. So, in other words, as the quality of the attorney's arguments increase, which you can see left to right on this x-axis, the probability that a justice votes for the ideologically opposing side also increases. So if an attorney makes bad arguments, we don't expect like 20% probability that a justice votes with the attorney making those arguments. But even if you are ideologically predisposed to be in opposition to that attorney, if that attorney offers really high quality arguments, suddenly we see the greater instability in the voting choices. It means that if you have a liberal lawyer arguing for a liberal outcome, conservative justices are almost 55% more likely to vote for that side than the other side. So we would favor that quality attorney for everyone at a more than 50% chance. For liberal justices, for that liberal attorney, the probability if that attorney is making quality arguments, increases to almost 100%. The same is true if you have a conservative attorney arguing for a conservative case outcome and liberal justices, that the quality of arguments can overcome ideology. And that offers really strong evidence that the quality of arguments and the characteristics of the attorneys themselves do significantly affect judicial decision making. That's pretty notable, right? That as we move up in quality, the probability of voting for that attorney who makes quality arguments increases, regardless of ideology. So it doesn't matter if you agree ideologically with the attorney or not. So super notable. All right, so let's bring this back to think about how the results of this analysis comport with the various theories of judicial decision making. We know that both the legal and attitudinal models predict that attorneys shouldn't matter, while the strategic model predicts that court procedures, including oral arguments, could in fact hold sway in judicial decision making. The evidence that we looked at today suggests that there is a role for both attorney experience and attorney quality in judicial decision making. Attorneys with more litigating experience before the court are likely to prevail over their less experienced counterparts. And more importantly, the quality of the attorney's arguments influences judicial behavior in systematic ways, where higher quality arguments are more likely to attract the votes of the justices regardless of ideological predisposition. Results certainly lend support to the strategic model of judicial decision making, while indicating that the legal and attitudinal models are less persuasive accounts. Specifically, because we see a systematic impact of attorney experience and quality in the likelihood that a justice votes a given way, we are less inclined to believe that justices are driven only by their own ideological beliefs, for example. So in this short and sweet lecture, make sure that you understand how an attorney gains access to the Supreme Court. Think about the hypotheses that are generated by our theories about whether or not attorney experience and quality ought to matter, then use the evidence to evaluate what attorneys are more likely to be successful before the Supreme Court. What are the characteristics of the attorneys? What makes a high quality case? How does quality matter? Do those things and you will have taken away what I hoped you have gleaned from this lecture. In the next one, we'll pick up and talk about the particular influence that the Solicitor General has before the United States Supreme Court.